4200 DC, Jeremy Simpson versus Gene Topekis. Today is Monday, January 8th, 2024 at 9:56 a.m.
Court will note the appearance of Ms. Reed on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Reed.
Thank you, Your Honor. The parties share one child together. That's Joseph, who's age 4. Plaintiff is requesting sole legal, sole physical custody of the minor child. The defendant having supervised parenting time. The defendant has had minimal contact with the child, even though the parties share the same residence. She is taken to locking herself in her bedroom. She repeatedly hits the child, and most recently she bit the child, leaving a bruise on the child with teeth marks. The child is afraid of her, and due to her lack of supervision, the child has been permitted to wander off while in her care. And for all these reasons, my client does not let the child be alone with his mother. There's usually himself or a roommate, or the child is in daycare, so the child is not left alone in her care. Since she has been served, there's been repeated threats to kidnap the child. Last week, she has stated that if it does not today, that it doesn't matter what the court is going to do, that once my client gets home from work, she will not be at the home, the child will not be at the home, and he will not be able to find her. For all these reasons, we're requesting that she have supervised parenting time, submit to a psychological assessment with Dr. Haugen, and my client gets sole legal and sole physical custody. He is trying to find alternate housing to try and alleviate some of the stress that's going on in the house. But until the parties separate, we believe supervised parenting time is appropriate.
Okay. Mr. Topekis, what's your response?
Is that on to me now?
Yes.
The allegations are not fully accurate, Your Honor. I want 50-50 custody, and I request an attorney, an appointed attorney.
Okay, ma'am, we do not appoint attorneys in these types of cases, so you'll have to acquire an attorney. Okay.
I just wanted to ask. But also, the allegations are fully out of bias. They are out of context. And I am also going to get help for my depression, yes. But I believe that the child deserves 50-50 custody. And I am not saying Jeremy does not have a right. And also, with him knowing the fact of the allegations are not fully understandable. He basically is taking bits and pieces of it, Your Honor.
Yeah.
And for right now,
go ahead. Anything
if it
else?
was the case, Your Honor, if it was the case if he was feeling unsafe with me with our child, why is our child in my care right now?
Well, anything else, ma'am?
No, not seeing, Your Honor.
Anything else, Ms. Reed?
Yes, Your Honor. It's my understanding that the child might be in the care of the defendant right now. She made threats of getting potential PPOs against child care providers to bolster her case, and then went back on those threats. We don't know how valid those threats are, but that was part of the threat of kidnapping after today's hearing, was that my client wasn't allowed to permit the child to go to child care today, so the child would be in her care pending the result of today's hearing.
Okay. Anything else, Mr. Topekis?
Your Honor, I asked, and also the caretaker actually even asked me if I wanted Joe home today, and I said yes. In my opinion, our friend who was staying with us was here to help me, not hinder me. She also has stated to his lawyer that she will also be defending me on my behalf also, Your Honor.
Okay.
And I was informing him of what my sister was telling me what to do. But, Your Honor, I would not do that to him.
Okay. Well, ma'am, just so you know that the child is in the jurisdiction of this court. And the court, when I grant, whatever I grant, that will be an order of the court. If you violate that
Yes, sir.
court order, you could be held in contempt of court, you could be put in jail. So all I'm saying is that whatever that order is, you're gonna need to comply with that order.
Yes, Your Honor, I will fully comply with your ruling. I'm not going against it whatsoever.
Okay,
But also, he is not home every day, and he is in childcare from all the way till 4 a.m, all the way till he gets home at midnight.
well, that's always unfortunate, and we'll maybe have to assess that at some point in the future as to what we're going to do in this matter. What I'm going to do on a temporary basis, I'm going to grant to the parties temporary joint legal custody. I'm going to grant physical custody to the plaintiff. The parties are, again, apparently still residing together, so they can work out parenting time in the meantime. If in fact there is no agreement, then the court would grant to the defendant standard parenting time, which is alternating weekends, one night through the week, alternating holidays, etc. Court will grant child support consistent with the child support formula, the incomes of the parties. And I'm not going to do anything as it relates at this point to the psychological assessment. The defendant has represented that she's going to get help for her depression. So, ma'am, when you do get help for the depression, provide that information to Miss Reed so she would have the information as to where you're going, who you're seeing, because the court will at some point want a report from that particular counselor. Anything else, Miss Reed?
Is the defendant's parenting time supervised?
No, I'm not going to do that at this point. Again, depending upon anything happening in the future, the court could review that at that particular time, but I'm not going to at this time.
I have nothing further.
Mr. Pekas, anything else?
No, Your Honor.
Okay, that will be the order of the court. Ms. Reed, you can prepare an order pursuant to 7-day notice of entry, and we'll have that order take immediate effect as of the time of this hearing.
All right, Your Honor.
Okay, thank you. You're free to go. Have
Yep.
a good day.
Keeler.
Yep.
All right, calling case 2015-1835 DC, April Keeler versus Daniel Miller. Today is Monday, August 28th, 2023 at 9:46 a.m.
Court will note the appearance of Ms. Reed on behalf of the defendant. Plaintiff superior in pro per. Plaintiff has filed an objection to order. Ms. Keeler, you can proceed.
I only work part-time because I get Social Security and I do home care. So it's up to like if I get a client or not, if I have a client or if I'm picking up shifts. Right now, I do not have a client. Whenever I can pick up shifts, I pick up shifts, but nothing is guaranteed. And I never will work 40 hours because I get Social Security.
Okay. Ms. Reed, what's your response?
At the evidentiary hearing, this honorable court imputed the plaintiff at $15 an hour for 40 hours a week as she cut off and left the hearing early. The orders that were submitted under the 7-day rule accurately reflect the court's ruling, and it's our position that the objection is not proper pursuant to MCR 2.602 Paren B 3B, and we're requesting that the proposed orders that were submitted under 7-day be entered, and we're requesting attorney's fees in the amount of $750 as this objection is not proper.
Okay. Any response, Ms. Keeler?
As far as the rejection, I came down to the courthouse and that's what they directed me to do and fill out.
Okay. Well, what happens is they may have directed you, but the court does find that the objection is not proper pursuant to Michigan Court Rule 2.602, parens B, parens 3, parens B. In this particular matter, the court had imputed income at that point. So what the court is going to do at this point, the court is going to deny the objection, enter the order. If you have some subsequent basis, Ms. Keeler, you can always file a motion in that matter. I am going to reserve on the attorney fees should further hearing be necessitated in this matter. Ms. Reed, I ask that you prepare that order denying the motion and reserving on the attorney fees in this particular matter. The court will enter the order as submitted. That will conclude. Court will note the appearance of Mr. Vollmerine on behalf of the plaintiff, defendants appearing in pro per. This matter is before the court on the defendant's objection to the referee recommended order. Ms. Wilson, you can proceed.
My objection obviously has to do with the fact that the evidence that I submitted to the court was not properly scanned in. He had referee Croto had no paperwork that I had given to the clerk's office in any logical order. I have no idea what did actually end up on his desk and what ended up not being on his desk to be able to correct the situation. Nor am I versed in Zoom to be able to screen share. I told him, I was like, okay, next time we get together for a hearing date, I will obviously have perfected those skills in order to make sure that he has the proper documentation and I'm able to present that to both the plaintiff and him during proceedings.
Ma'am, you understand that in the notices and the whole thing on the Zoom, it tells you that you're responsible for those documents and you're responsible for making sure that you are able to screen share those and present those to the court.
That wasn't ever on my screen. That warning was never on my screen.
Okay, well, it's your responsibility as a party. It's no different than Mr. Vollmerine. If he wanted to present something and he couldn't do it at the hearing, it's nobody's responsibility but his. So in your case, it's your responsibility to make sure that those are able to be shared and presented to the court.
Okay. Yeah, that was not on the screen that I saw at all. And in addition to that, like this documentation was not properly scanned in by the clerk's office anyway. So he had no way of even knowing what I was presenting. Either way.
Again, it's your responsibility. So.
Okay, so when I hand in the paperwork to the court for evidence, for submission of evidence, and he does not receive that documentation after it's out of my hands, there's nothing I can do about that particular line of evidence submission.
Well, there's a lot of things you can do. You can, as you already acknowledged, you can do the screen share. You can present it. I don't know if this hearing was in person or not. I assume it wasn't.
It was via Zoom. Sorry.
Okay. So, but it's your responsibility to make sure that those get submitted at the time of the hearing. Because what will happen when you submit documents to the clerk's office, it's not unusual. The parties submit voluminous documents, and yet they may use a fraction of those documents at the hearing. Just they determine that they're not useful or that they don't want to admit them, etc. And so it's your responsibility to make sure that that gets done properly. So go ahead.
Also, there was the referee in-camera interview. Do we have access to that interview?
An in-camera interview is privileged and confidential. We do not have, it is not shared by anyone. It's not to leave that particular room. So the parties, the attorneys, even myself will never find out what occurred at that interview.
And the next issue was the fact that referee Croto had stated in previous proceedings that he disliked breaking up testimonies from witnesses. So I did not subpoena two of the witnesses that I was going to have to recall due to that fact that he had stated that displeasure in that. In the last day, it was forced closing. The closing statements was demanded, even though the paperwork was not correct. I told him that I would learn how to submit the paperwork via Zoom screen and everything, but there was no chance at all for me to counter an expert witness. I have no idea what he admitted to, not ever calling me back, never contacting me. And there was no opportunity for me to rebut his testimony as an expert witness.
You called, didn't you call a CPS worker and had that person testify?
I had the one person, yes.
Okay, so you know how to get somebody to testify then, correct?
Yeah, and I was not afforded the opportunity to get the evidence I needed for an expert against an expert witness. He testified.
There was a hearing on May 12th and then again on August 3rd. You could have subpoenaed an expert for either of those particular hearings.
And I would have if I knew what the plaintiff's expert witness was going to testify about.
You can't just say, well, geez, they've presented their witnesses and now I think I need an expert. That's not how trials work, ma'am. You have to have your witnesses present and available for testimony.
And I understand that. However, the simple fact is the expert witness that the plaintiff called would not contact me back. And I have no idea what he's going to witness against. So therefore I have no recourse as to this is the expert witness that I would call to counter his testimony.
The other party's experts are not required to contact you back. They're not required to have any communication with you. They're the other party's witnesses. They're the other party's expert, and they testify at trial. And you have to prepare your case, just as Mr. Vollmerine had to prepare his case, and present the case as best you can. You can't, if you wanted to have, let's say, information, or you wanted to have forewarning as to what the expert was going to testify, you could have had that expert take a deposition, and you could have went through all of that testimony at that time in preparation for your hearing.
With the witness who does not get back to anyone, including the CPS witness.
You subpoena the person and they are required to show up for their deposition. Or if you subpoena them, they're required to show up for the hearing. So obviously you have a disadvantage a little bit because you're representing yourself, but that's the responsibility that you take on when you represent yourself and don't have an attorney. So that's unfortunate. Anything else?
Yeah, the wording of that the referee put for the attorney fee section, last page, third paragraph, it implies that I'm to pay all attorney fees in the show cause hearing, which is what the entire custody case is the show cause. He didn't specify it was the show cause for contempt of court or if it was the show cause for the entire situation.
Okay. Mr. Vollmerine, what's your response?
She did not put that in her objection, Your Honor.
Okay. Anything else, Mr. Vollmerine?
I guess I'll just add to that. There were two competing show causes. I asked for attorney's fees on both of them as a result of frivolous pleadings filed by the defendant here. So my interpretation was that it applied to both of those show causes.
Okay. Anything else?
No, Your Honor.
Okay,
Well, I'm sorry, is this in response to all of what she was
Yes.
saying or that
in
one part?
response to everything.
Okay, I guess as far as the other items go, yeah, I think the court pretty well hit on it, and I also will primarily rely on my pleadings there, but it was the defendant's responsibility to subpoena her witnesses and to prepare her documents and exhibits for trial. She has shown an ability to do so in the past and just chose to not do so this time. And so I'd just like to reiterate, I'd like attorney's fees for having to appear for this motion as well.
Okay, thank you. Anything else, Ms. Wilson?
Apparently not.
Okay. Well, in this case, the court did have opportunity to review the ruling of the referee. He did make a very thorough factual and legal decision in this particular matter. He did address and found issues of credibility to be substantial in this matter, as well as finding that the established custodial environment was with the plaintiff in this case. And as a result, the court, after I reviewed that and thoroughly reviewed it, the court cannot determine that the referee made either a factual or legal error in this matter. So the court is going to deny the objection in this matter, and that will conclude the case. And
I do have something that's slightly off topic that has to do with paperwork and filing in your guys' office, if you wanted to hear about it.
well, if it doesn't go to the objection, I don't care to hear about it because it's not before the court today.
So the fact I have somebody else's information from their court date and their rulings and their custody case in my envelope sent to my home isn't concerning.
Well, that obviously it's always of a concern, but it doesn't affect these particular proceedings. And what you need to do is you'll need to file a complaint with the front of the court because they would have been the ones that sent that out to you. So you can file a complaint with them.
Okay.
Court will end this matter at 10:46 a.m. You're free to go. Have a good day.
Your Honor, real quick, on my attorney's fees, was that denied?
I'm denying that at this point. Yeah.
Thank you.